Over the past few days, we have seen these misinformed, sensationalized headlines that talks about how Chadwick Boseman's estate lost $1.5 million in value to the government and another $900,000 in value to court probate fees. And if that isn't bad enough, you have influencers who are going on Instagram regurgitating this misinformation and then using it as a teachable moment to promote a course or a class. And it's like watching a game of telephone gone horribly wrong. And this is how misinformation gets spread quickly. And unfortunately, it's usually the misinformation that gets spread faster than the facts. So in this video, I'm going to use Chadwick Boseman's estate to explain the probate process in California, and I'm also going to point out some common misconceptions and alleviate some common myths as it relates to the probate process and his estate. And I know there's a lot of you watching this who are interested in real estate investing and house flipping, so as I'm going through the process, I'm going to point out some things that you need to pay attention to in particular. So all right, let's dive in. First things first, what is probate? Probate is a court-supervised process which transfers any assets in a deceased person's name and transfers those assets into the names of their heirs or beneficiaries. One big misconception is that if a person has a will, this will avoid probate. This is completely false. Whether a person has a will or does not have a will, they still have to go through the probate process. However, having a will usually helps to reduce the amount of bickering and going back and forth. But that's not always the case. One thing you have to understand about the probate process is that it is a very public process, meaning anybody who's nosy like me, anybody who's intellectually curious like me can just go to the probate court's website, enter the deceased person's name, find out the case number, and then use that case number to look at all the documents that were filed related to that probate case. So let's look into those documents. So the first document that is usually filed is the form DE 111. This is the petition to start probate and the petition to get letters of administration. This is usually filed either by the person who is trying to be the personal representative, or if that person has hired an attorney, the attorney will usually file it. That form costs about $465 to file. On that form, there's a couple of things you want to pay attention to. Number one, you want to pay attention to who the deceased person is. Secondly, you want to pay attention to who is filing the document, who is trying to be the personal representative of that estate. Next, you want to pay attention to the value of the assets in the estate. And for those real estate investors out there, you want to see if there's any real property inside the estate, meaning does the deceased person own any houses? If they do not own any houses, there's no point in going after and pursuing this probate file, and you could just keep on moving to the next file. The next thing that is listed on this form are the heirs and relatives and potential beneficiaries of this person's estate. So what was interesting to me about the information that was on this form was that Chadwick did not own any real estate assets. Under that section where it says to list the value of any real property that the decedent owned, that was blank. It had a 0 in it. I was really shocked to learn that Chadwick did not own any property. Now, after this DE 111 petition is filed, there's usually about a 6 to 8 week waiting period in order to have a hearing date. Now, at this hearing date, the judge will either grant or deny that personal representative's request to be the administrator of the estate. Now, if everything is going smoothly and no one is objecting, then it is usually granted. So in Chadwick's case, his wife, I believe her name is Taylor Simone Leeward, she was the personal representative. She was the one who filed the petition to be the personal representative so that she could be the administrator. And you can see right here where she was granted that request by the judge. So while the estate and the personal representative is waiting for the hearing date to actually take place, a couple of things need to happen. Number one, they need to give notice to any heirs and beneficiaries that this hearing date is going to happen. So the notice is basically a legal paper that says, hey, my name is, in this case, Taylor Simone Leeward. I am applying to be the personal representative. If you have a problem with this, you need to show up to LA Superior Court on this date at this time in this department. And the department is just the court's way of saying the court number, the courtroom number. And then the second thing that usually happens while the estate is waiting for the hearing date is also what we call the notice of publication. Now, the notice of publication is basically, I don't know if you've ever looked in the back of a newspaper and you see these sort of like legal proceedings publications that are kind of like in a smaller print and kind of like a column looking thing. That's what we call a publication, and it's basically just putting the world on notice that, again, hey, I am trying to be the personal representative of this estate. If you have a problem with that, show up to court on this date. Now, once the hearing date comes and no one shows up to object, then the probate judge will usually grant the petitioner's request to be the personal representative, to be the administrator of the estate. Now, once that petition has been granted, the next step is to get an order for probate and to obtain letters. Think of letters as the personal representative's permission slip that gives them the authority to take care of the deceased person's business, handle business like talking to banks, and as it relates to us real estate investors, the letter now gives the personal representative the authority to sign a purchase and sale agreement so that we can purchase the house that is inside of the estate. Once letters have been issued, it is important to note what type of authority does the personal representative have. Do they have something called full authority, where the court is a little bit more lenient and gives the personal representative a little bit more leeway as it comes to handling the business of the estate? Or does the personal representative have limited authority? Now, when a person has limited authority, any and everything they want to do as it relates to the estate has to be approved through the probate judge. Now, in this case, as it relates to Chadwick's estate, his wife had what we call limited authority. Now, because he did not have any real property inside of his estate, he did not own a home. Therefore, in this case, limited authority doesn't really matter. However, let's just say that Chadwick did own a house, and let's just say that the wife decided to sell that house. Now, she would sign a listing agreement with a real estate agent. That real estate agent will put that house for sale up on the MLS. Now, let's just say they listed the house for, I don't know, $1 million. And you, the real estate investor, came in, ran your numbers, and say, hey, I'm willing to buy this property for $1.1 million. So you offered $100,000 over their list price, and they accepted your offer. So Chadwick's wife signed your offer, accepting your offer. However, because she has limited authority, that doesn't automatically mean that your offer is the winning offer. When an estate has limited authority, that offer is still subject to court approval, and it is subject to the court overbid process, meaning that in a future date, usually about a month or two down the line, after that offer is accepted, there is a court date where, say for example, the judge will be like, hey, the winning offer was $1.1 million. We need a minimum overbid of $1.15 million. And someone could come in and overbid. And it can create a bidding war. It could go up to 1.15, 1.12, 1.13, so on and so forth. So it is so important as real estate investors, if you do lock up a property that has limited authority, you may or may not actually close on that deal. So once the property goes through the court confirmation process, an order confirming sale is then issued. Now, what I forgot to mention earlier, usually while the personal representative is waiting for letters to be issued, they need to obtain something called a bond. Now, a bond is basically an insurance policy that kind of protects the heirs and the beneficiaries of the estate, just in case the personal representative was to go rogue and run off to Mexico with the money, right? So think of the bond as like a life insurance policy, or just overall an insurance policy to help protect the heirs and the beneficiaries. Now, in this case, as it relates to Chadwick's estate, the estate had to get a bond in the amount of $939,000. Now, that's where that $900,000 in court fee headline is coming from, and that is completely misinformation. The bond is just the bond amount. They did not have to pay that amount to the court. So if you read a headline saying that $900,000 had to be paid to the court, that is completely false. If you look right now, the only amount they had to pay to the court was the premium, which was about $2,600. They did not pay $939,000 to the probate court. Again, think of it like an insurance policy. If you have car insurance that's valued at $500,000, you're not paying $500,000 every year. You're only paying that premium amount, right? So think of it like that. So the estate did not pay $939,000 in court fees. So that headline is completely false. So around the time that letters are being issued, around the time that the personal representative is obtaining and qualifying for a bond, the court judge will order that the estate is inventoried and appraised, and something called an inventory and appraisal is filed. And this is where what we call a probate referee will come in and give their opinion of value of all the assets that are in the estate. Now, if the estate just has like cash and stocks, maybe some mutual funds or something like that, those are really easy to determine the value of. However, it gets more complicated for the referee if there's stuff like real property inside of the estate. They have to determine the value of that real property, determine the value of that house. And it gets a little bit more tricky when the personal representative has limited authority, because there is a probate code or section or whatever you want to call it that says at minimum the house has to sell for at least 90% of the appraised value. So this could get kind of tricky if, maybe you are trying to bid on a house and the probate referee thinks the house is valued at one price, because they don't really go inside and look at the value of the property and look at the condition and stuff like that and take that into consideration when they're getting the value. They just sort of do like a drive-by, and quite frankly, I don't even think they do that. But anyways, it could get a little tricky if they think the value is much higher than your offer and it doesn't, add up to the 90%. That could be a potential problem for the estate and for your offer. So the number that the probate referee values the estate at is super important, because that value is going to be used to determine the legal fees that the attorneys and the administrator is entitled to. It's important to understand that the probate attorneys do not get paid hourly like a typical attorney. They get paid based upon statutory fees that have been predetermined by the court. Here in California, those statutory fees break down like this: 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, and 1% of the next $9 million, and I believe it's 0.5% of the next $15 million. Now, Chadwick's estate was valued at around $3.8 million. And that is the number that was used to determine the fees that the attorney and the administrator, who is his wife, would get. So if you were to do the math based upon that breakdown I just gave you, the attorney and his wife would be entitled to about $51,000. And as you can see, that's what was reported in the final accounting. And you can also see in the final accounting, his wife waived her fee. Now, early in the probate process, the attorneys and the personal representative will usually send letters and notices to a couple of organizations, one being the California Department of Health to see if there's any outstanding medical bills or Medi-Cal or Medicare or whatever you call it. I get those two confused. See if there's any claims and unpaid medical bills that the deceased person has that needs to be taken care of by the estate. There's also a notice and a letter that is sent to the California Franchise Tax Board to see if there's any unpaid personal taxes that are owed. And then there is also kind of like a period where any creditors that feel that they are owed money by the deceased person, they could come forward and say, hey, this dead person owes me money. The estate needs to pay that bill. Now, in the case of Chadwick, he did not have any Medi-Cal or Medicare bills that were unpaid. You can see that on your screen. He also did not owe California any tax, and the one creditor's claim that they did have was from his wife wanting to be reimbursed for some funeral expenses that she had, which seemed fair. She asked for a reimbursement of $71,000. However, the judge only granted her a reimbursement of $47,000. I'm not sure why. If you want to know, you can spend the money on the legal docs and look it up yourself. So as I alluded to a few moments earlier, the next and final step is to do the final accounting and an order for distribution. And this is basically a log of all the expenses and assets that are in the estate, anything that had to be paid out. And then the distribution is going to determine what percentage each heir gets. Now, in this case, his wife got 50% and his parents got 50%, which the mother and the father got an equal share of 25%. Now, this final distribution doesn't happen until months or maybe even years after that initial petition was filed. So, looking at the petition that his wife filed, that was filed in October of 2020. We're now in around the summer of 2022. So it's almost 2 years until the estate is able to distribute those assets to his beneficiaries and heirs. And that's super important for those of you who are working with people who have property in a deceased person's name. They need to understand that just because they sold the house a few months ago doesn't mean that they automatically get those proceeds. Those proceeds sit in an account and they do not get distributed those proceeds until months later. So it's super important that people understand that when they are going through the probate process. I know I just went through a lot of information and you may even have to rewatch this video and take some more extensive notes, but here are a couple of takeaways that I want you to get from this video. Number one, you cannot believe everything you read. Sometimes headlines are just made and created as clickbait, right? So that headline said that there was $900,000 in court fees. That was completely false. I showed you that was just the bond amount. And then secondly, it said that $1.5 million was given to the government. I showed you that the estate did not have to owe or pay any California taxes or any federal taxes. Secondly, I want you to realize that probate is a very timely process. I didn't really explain all the timelines in detail, but typically a probate can take anywhere from 9 months to a year to more, depending on if the family members are fighting. Now, I believe that this probate went relatively smooth. The wife filed the petition in October of 2020, and we're in the summer of 2022, and the estate is about to get finalized. So that is about a year and a half, and this estate went what I feel relatively smooth. So I want you to take away that the probate process is a very timely process. Okay, it's very timely. It is very public, right? You have absolutely no privacy. All I had to do was go on the court website, pull the name and the case number, and I was able to access all the documents that were filed related to the case. And that's why you should have a trust. A trust will protect your privacy. A trust will reduce those timelines, and a trust will also help you to access those proceeds from any sale of real property a lot quicker versus when the house and the estate is subject to the probate process. Now, before I end the video, I need to go on a quick rant and soapbox for all y'all making these dumb BS comments trying to drag the wife, saying that she took too long to start the probate process, she took too long to actually do the probate process, that she didn't know her rights, and that she should sue the government for taking all this money. And for those of y'all who were making comments about, oh, the family was fighting and that's why it took so long, those are all BS comments, and y'all need to stop it. Number one, the petition was filed 2 months after Chadwick's death. He died in like August, and I believe the petition was filed in October. So within 60 days, this woman watched her husband die, buried him, and then started the probate process. Now, for those of y'all who are talking about she took too long, y'all need to sit down and have several seats, because I'm pretty sure there's some property in your family where your uncle and your auntie is living in grandma's house, who has been dead for the last 20 years, but the property is still in her name. Y'all have not done anything to transfer that asset, so have several seats talking about the wife took too long. Also, for y'all who are saying that the family was fighting and this is why it took too long, that is completely untrue. I did not see not one competing petition from not one family member, and I did not see anything from the parents saying that, oh, I think I should be the administrator, I should be the personal representative, I think I should get more. I didn't see any of that. So there was no fighting between the family members. So for y'all who are making comments about that, again, have several seats. And also for people who are saying, oh, they need to sue the government because the government took too long and that's why they got all that money. Again, sit the down and shut the up. Like, the government didn't barely get any money. I showed you there wasn't any taxes paid to the California Franchise State Board, and there was no taxes paid to the IRS. So where are y'all getting this information? Okay, rant over. So for real, y'all, let me know what you learned in this video. Let me know if there was any new information that you learned, maybe something that you thought was how it is, but it really wasn't. Hopefully I was able to bring some light and some facts to the probate process, and using Chadwick as an example. I hope that was helpful. Let me know in the comments below. And if you haven't already, be sure to subscribe to my channel. Click that notification bell, and that way you'll get notified the next time I produce a YouTube video. And if you haven't already, check out my video. There will be a link somewhere on the screen where I talk about driving for dollars. Probate is an excellent way of finding deals at a potential discount. Driving for dollars is another way to find those deals. So be sure to check that video out, and I'll see you guys next time.